Yes, it will be in person again.
Ms. Griggs next one.
Actually, I'm calling both matters. Court will call the case of the state of Michigan versus Shauna Cunningham, 23S00013, as well as the state of Michigan versus Jada Griggs, case number 23S00014.
Rachel McDuffie for the people.
I'm on behalf of Ashana Cunningham.
Both better. I believe on behalf of Jada Griggs, who is approaching to my right. That's great. Please state your name.
Jada Griggs.
Please thank you.
Ashana Marie Cunningham.
Thank you. You all may be seated. All right, both of these matters are here for sentencing today. They have recommendations for immediate jail time and they're in person because at this point in time, I intend to follow that unless I'm convinced otherwise.
You go first.
Why don't you start, Ms. White?
I'm not sure if we went through the corrections or anything in the sentencing. Did we already do that?
I don't think so.
Okay. As to the body of the report, we do have one correction on page. It's number page, or I might have mine out of order, but it's page 2. Under summary, the second sentence said the defendant pled guilty to this charge. She was found guilty after trial.
Page 2, second sentence.
Under summary,
Oh, I see. Thank you.
outside of that, we don't have any other corrections, deletions, or additions. I'm ready to give a recommendation when the judge is ready.
All right, thank you. You may proceed.
As to the recommendation, I ask that you do
Wait,
not follow the
1
recommendation.
second, I'm sorry. Miss McDuffie.
Your Honor, my comments will be the same on both of these cases. These are 2 co-defendants. We had a joint bench trial with both co-defendants, and both were convicted on as charged. It was noted by the court at that time that they did not testify and didn't have to, obviously, in their own defense. But in reviewing this report, it was noted by that time at the court that there was no other explanation for what happened that could be a credible one, I think is the best way I can sum that up. Looking at the comments here, there's absolutely no engagement with responsibility whatsoever in any way here. I think back to sort of the defenses that they weren't even present at that time. And so I just don't know what it's going to take to change that. Unfortunately, I think that sometimes when there's a trial, people are even more inclined to continue to maintain their innocence, feeling like they got a raw deal, so to speak, and not believing that anything took place here. So I don't know what it's going to take to change that, if anything. But I'm troubled by what I see here from both co-defendants. So I agree with the recommendation.
Thank you. Why don't you, at this time, go ahead and do your allocution on behalf of your client?
I ask that this court do not follow the recommendation of 10 days in jail. Ms. Cunningham does not have a criminal history. She takes this process and what has happened very seriously, and the fact that she now does have a criminal history. She has been very distressed and unable to sleep over this matter. She plans to start cosmetology in November, and she does have an orientation today of a new job. She has proof of that, and we've talked about it. It's today at 3 o'clock. She starts with CVS. She's been looking for a job for 4 months, so she's very happy to have now found a job. And she looks forward to this chance to get back on her feet. I do believe she is a good candidate for probation for the fact that she's had no criminal history whatsoever. And I asked for this chance to give her a chance for her to show this court that she would be a good candidate for probation. And again, I ask that you do not order the 10 days in jail, because I do believe she could be compliant on probation and show this court what type of person that she really is and that she is. As for what Ms. McDuffie said about her statement and her sticking by her statement That is how Ms. Cunningham, that is Ms. Cunningham's statement and what she stands by, what has happened. So, I have advised Ms. Cunningham that she does not have to give a statement. We've talked extensively about it. I don't know if she wishes to give a statement, but as I stated, I did advise her that she does not have to.
All right, thank you. Ms. Connigan, is there anything you'd like to say prior to sentencing?
Yes, I'm sorry, I'm not really good with,
Please stand.
I'm not really good with public speaking, or, you know, I'm really not good with stress either. I've never been in trouble. I've never had any type of prior convictions. I've never been in any type of trial or anything of the matter of the sort of having to be in court or prolonging situations. Mainly for me, I just want to be able to start over. Like, it's already been a long road. It's been really hard. And for me, like, coming into like 22, going into 23, I've been trying to keep going and going and going. And it just seemed like this is just getting in the way of me succeeding or like having any type of way to really show y'all that I'm not that kind of person or living by what this is going for. I'm not really good at this. Overall, I don't want to be back here. I don't want to come here. I don't want to see nobody's jail room. I don't want to see nobody's courtroom anymore. Like, I get it. I understand. I just hope you have some type of leniency or care. That's really it.
Thank you. I see your client.
Look, we have no modification to the body of the report. I would like to allocute and request the court not to impose the 10 days in jail.
Well, I believe that Ms. McDuffie has said that she was saying the same thing on both cases. So is there anything additional you need to say at this time, Ms. McDuffie?
No, Your Honor. I'm sorry. There is one thing, I believe, Your Honor. On this case, Your Honor, the thing that did concern me on this report that jumped out at me, everything else I said, I think continues. I believe I saw a reference that the sort of denial in this case was that she didn't have that type of crowbar. I don't know if that's a admission that owning a different type of crowbar that was used in this incident, but that really caught my attention because I don't know, that something about that was just really telling to me. It wasn't even that I wasn't there so much that I don't have that particular type of crowbar that was used in this incident. That was all. That just jumped out at me in this report.
I'm gonna go to you first, Mr. Lebo. But then I'm gonna come back to you, Ms. White, because another thing that is concerned is that it says that the defendants continue to harass the victim on social media. Have you got a chance to talk to your client about that?
If I could have just one moment, Your Honor.
You may.
Did you want to speak on that?
Have you already talked to your client? Are you ready?
Yes, we've talked about this. Ms. Cunningham has her blocked as much as she can. We have screenshots of Ms. Eddings reaching out to her. She's done fake pages. I told her to continue to block them.
I'd like to see that.
Yeah.
My mom has my phone.
She continues to harass her. So they keep blocking and they keep trying to block the fake pages when they come on. She does friend contacts, they look to see who it is, and then they block it. Okay, this is one with them. She's posted outside. That's outside their mother's home, her mother's home. She went by and took a picture.
How do I know that? How do we prove that this is her? This
That's
says.
her Snapchat name at the top. It's still the same one.
Okay, how do we prove that this is her? That is, how does the court know? This could be anybody, it says Alajay.
That's her name.
Oh, she's saying, how do we know? I guess that's all.
I can pull up her Snapchat name on my phone if need be. I still have it. I'm sorry.
Is there a picture that goes along with this to prove anything that you're indicating today?
Just her talking about my brother. Like, the top, when it's a Snapchat, it just has the avatar at the top. And usually when people post like their pictures and stuff, it just comes in around the circle. But that has been her Snapchat and has remained her Snapchat. That is the only app I still have her.
So this happened 4 months ago, the one that was sent, even if we could prove that it was her, which I'm not seeing the proof of that just yet.
She also has contacted my mother as well. She just deleted the message thread on her phone. She blocked her.
Mr. Driggs likewise tells me that she has a complaint witness blocked on all social media and denies this allegation of contact.
All right, anything else you can go ahead with at this time, Mr. Weaver?
Yes, sir. I did have a fairly extensive discussion about this matter with Ms. Griggs, and she tells me she is now prepared to take responsibility for her actions. She tells me that she's going to be telling the court that she admits that she let her emotions get out of control, that she made some very severe mistakes, including even the initial decision of going over to the complaining witness's house, and she regrets that. She's now working very hard to improve herself. She's employed as a CNA at the moment and is currently going to be seeking further education to further herself in the healthcare field at Dorsey schools. So we're asking the court to take Ms. Griggs' acceptance of responsibility that she now is willing to admit at this point, as well as her efforts to improve herself into consideration and consider omitting the 10 days in jail and perhaps replace them with some community service instead.
Thank you. I'd like to hear from you. Please.
Yes, Judge, I do accept responsibility. I did let my emotions get the best of me at the time, and I have learned from my mistakes over the past months, dealing with a serious matter of this. As far as like anything further than, like, it has been no prolonging the situation since the beginning. And speaking of like the crowbar comment, I just was speaking about mentioning, they said it was 2, it was only, like I said, I admit to it, it was only 1, it was not 2 being used. That was the reason why I made the crowbar comment, because I was trying to, you know, go into telling her how everything built up, and she was trying to, like, I guess she wanted me to, I guess she took it as if I was trying to be the victim, but I was trying to tell the probation officer how everything came about, like the buildup of everything. But
tell me about that. How did we get here? I mean, we got 2 young ladies who apparently thought I couldn't see what really happened.
Basically, like, you remember when you guys had said, like, we know it's more to the story. Like, that's kind of where I was trying to get at with my probation officer, like, expressing everything of what was going on, because I couldn't do that inside the courtroom. But it all started, like, with her harassing off of fake pages and stuff, because I was dating the father of her child. Okay. So it started with that, and posting addresses and houses and stuff. And it just, like, it was just building up. And it got serious, like, to the point where people's stuff started getting damaged. Like, I'm gonna say my things got damaged as well, but that was in a whole different county. Like, I'm taking responsibility of what I did, you know? So I didn't really, you know, I was trying to just tell her, like, everything. I guess she took it as if I was trying to play victim, but I wasn't. I take responsibility of my actions. I just wanted her to get the understanding point of the buildup. That was all. But I do, I apologize to the victim and her mother and the court, everyone, for this time that we have. You know, you guys have, I don't want to say wasted time, but, you know.
Well, some of that was, because you knew what you did, and yet you tried to have a trial with no real defense.
Not so much of that. Like, I want to say how it was like more so trying to, like, explain my story. She's not just the victim. Like, we're all in this situation, could be suspects or whatever the case is. It was like a back and forth game, like a cat and mouse game. But I do accept responsibility for my behalf on the end of it. I just kind of wanted the court to know, like, what was going on. Like, it's not just someone, oh, I'm going with your baby father and I want to beef with you. Like, that's not what was going on. Like, it's not that I didn't know my place. I was getting harassed. So it was kind of more of I want to tell you guys more of what's going on to the story versus it being like, oh, no, I didn't, you know, like, it was kind of like. You
had an opportunity to have what's called hide up. So this wouldn't be on your record. You turned that down and decided that you wanted to have a trial. And now you're standing here before the court with potentially going to jail because basically you've been trying to convince this court that it didn't happen. That's how you got here. That's what a trial is. That's what a trial is. So you went through a trial, then you got convicted. You showed up the last time trying to convince the court that it still didn't happen. And finally now you're accepting responsibility for your part. And like I said at the time, I knew there was more going on because people don't just show up and bust out people's windows. So how we got there is what I've been trying to figure out this entire time. So I want to give you credit for at least accepting responsibility today and coming forward and saying the truth. It means a lot to me because it shows at least that you know when the rubber meets the pavement and you're not going to continue to play that game. So I appreciate that. All right, you can have a seat.
Thank you.
I do want to give an explanation as to Ms. Cunningham,'s summary of the events, if Your Honor doesn't mind. I had asked Ms. Cunningham because it's somewhat attorney-client privilege, as to why I wouldn't have her grandmother come in. And I had a discussion with her and her mother, but her grandmother has dementia. So we weren't sure what the testimony would be like. So that's why we didn't have grandma come in, and we just wanted to make this court aware.
I need the defendants and their representatives or moms to go in the hallway, and I need to speak with the attorneys, please. Thank you. Ms. McDuffie,
Yes, ma'am.
I'm gonna call the Griggs matter now. The court will call the case of the state of Michigan versus Jada Griggs, case number 23-00014.
Section executive for the people.
Fellow defender document before Ms. Griggs, who is standing to my right, please state your name.
Jada Griggs.
Thank you. Ms. Griggs, please stand and raise your right hand. You swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth under penalty of perjury, ma'am.
Yes.
All right, thank you. Ms. Griggs, I have some questions for you that I think your attorney has talked to you about at this time. I first of all still acknowledge that I am very pleased that you have at least come forth with the truth about your ability, your activity on that particular date. But at this time, I have some additional questions, as you know. Were you there? Who were you? Were you there with alone in this event, or was it two people?
It was more than two, but the events that took place, that was me.
You said it was more than two people that were there.
Yeah, it was me, the victims, and my co-defendant.
Your co-defendant was
Yes.
there? All right. Thank you. That's all I needed to know. Thank you. I will finish the sentence once she returns. We'll call the case of the state of Michigan versus Ashana Conigan, case number 23-00013.
Rachel McDuffie for the people.
Sandra White on behalf of Ashana Cunningham. Please state your name.
Thank you. All right, Ms. Conigan. I'm sure your attorneys had an opportunity to speak with you, and I now know who was there. So I'm done with the games. Do you understand me? Ms. White.
I have had an opportunity to speak with Ms. Cunningham, and she would like to address the court.
Thank you. Please stand, Ms. Conigan. No lies this time.
I was present at the scene, but the only reason why I didn't say anything at the beginning is because I didn't want to I don't want to get in trouble. I didn't want to put all this stress on my mom. So I came with the story to keep from her. And at the beginning when Hyder was offered, I didn't understand. I
told you, I made it very clear to you.
I'm talking about at the beginning when it was first presented to me. I didn't know what it was.
But before you went to trial, I talked to both of you.
So when it came down to it, this had already been going on previously, like before everything had happened, like before this whole matter. Previously, this girl had already been picking from 2019 to 2022. I literally lost 5 people during there. When she brought up my brother, I lost my brother 3 years ago. She brought up my brother. She said she was gonna it was a bunch of crazy foolishness stuff. So I did get upset. I did get irate, but I did not. I let my emotions get the best of me with everything, and I should have just owned up to it from the beginning. Like I said, I just didn't feel like putting all this stress on her no more or me, and I understand now.
But you were in here today still lying.
Yeah, I get it. I'm sorry. I can't do 30 days. I can't do none of this. I've never been to jail. I've never been nowhere of this sort. And I'm really trying. I really am. Like,
Since when, 5 minutes ago?
no, like, even beforehand, I've literally been trying to get back in the group of my lifestyle, my everything. Like, I'm literally building everything from the ground up again.
You lied to the court less than 10 minutes ago.
I asked my attorney, should I keep this going or whatever? She told me to just stick with it, now it's just time to own it, it's time to tell the truth. I can't. And I understand how upset you are, I get it. I know, and this is what I feared of, but I can't do this, I can't go, I'm sorry. I really am. I'm 22.
May I speak on her behalf, President? I know I've said a lot, and I said a lot at the bench, but I do believe Ms. Cunningham does deserve a second chance. I know she's made a lot of mistakes, Your Honor, but she has had no prior experience with the court. And I know someone should know lying is no matter.
She knew coming in here today that the only issue before the court was whether or not they were going to accept some responsibility for what they did in this particular case. They decided to go to trial, knowing that what they did was what they did. They presented no defense at that trial. Then when I spoke to them before we even got to that trial and explained they were losing an opportunity for HIDA, well, neither of them would have a record. They still continue with this farce. And now your client, even today, I had to go through the actual trouble of having someone else have to tell me what happened there before she would come clean.
And I think that's an example of the bad mistakes that they've made. And I think this case shows the bad mistakes that they made. I think this case shows some of the immaturity. I think her decision today shows her immaturity and the mistakes that they've made.
We're beyond immaturity at this point with her.
And I think.
And she stood there, she looked so innocent. And quite frankly, I was going, maybe we got the wrong person. Maybe we did.
And I think that all of this shows that Ms. Cunningham does, I think she needs a chance to show this court through probation, the type of person that she really is, as she stated earlier. And I think all of this shows.
She just showed me who she really is. All right. In the Jada Griggs case, ma'am, if you would stand, please. These are first offenses for both of you. And it's not the offenses that actually have you here. It's the lack of accepting responsibility for what got you here. It's the lying to the court that got you here. You, at least today, decided that you would no longer continue to carry on that farce. And for that, I appreciate that, and I'm going to give you a break. You were probably one of the main culprits because it's your boyfriend that's involved in this situation. But at least, yes.
Ex-boyfriend, I no longer want anything to do with this situation or literally putting everything past me.
But at least you came in here and were honest from the very beginning, understanding the severity of where we were right now. I don't know what led up to all of this, other than what you've told me, who was sending information back and forth. That's unfortunately not how the system works. You were standing there with a crowbar at some point, and therefore you got convicted. And as such, you have to pay the penalty for that. Is the sentence of the court that you serve 365 days? I'm gonna suspend all of that time at this point. You're on probation for 12 months. Fines and court costs in this particular case for a total of $625, $400 in restitution for the damages that is going to be shared with your co-defendant, so it's going in joint and several. $30 per month in probation oversight fee. You to meet with probation when and where directed, including any and all home visits, and make earnest effort to maintain legitimate employment. You must complete the MRT program. There's no contact with Jennifer Edens or Elijah Edens. No going to the residence or or place of employment of Jennifer or Elijah. No assaultive or threatening behavior towards anyone. You to submit to, pay, and be responsible for random drug and alcohol tests as requested by the court, probation, or police. No use or possession of any alcohol, marijuana, illegal drugs, paraphernalia, or being in the presence of anyone carrying those. And the same is true for firearms, firearm components, ammunition, or other dangerous weapons, and no being in the presence of anyone carrying or using those. There will be a review in this case in 45 days to see where you are.
Thank you, Your Honor.
I'll put that on for December the 7th, 23 at 10 a.m. You're all set. You may be excused. Come again.
I have a chance to talk to you. It's okay.
Go ahead.
I understand why you think I'm that kind of girl. But ma'am, I'm really not that kind of girl. I've never been that kind of girl.
The kind of girl who comes to court and lies to me?
I've never been in this situation, and
It doesn't matter. You know the right, you know right from
and I know
wrong.
right from wrong, and I didn't know what to do.
You did know what to do.
And I understand.
You have something you want to say, ma'am?
Her mother was out there chastising her. I mean, her mother, she didn't want to upset her mother, and her mother has found out everything, and this has been
Really long.
she's,
You caused it to be long.
I'm sorry. I really am.
Have a seat. Now, can you step up to that microphone there and tell me your name and say what you'd like to say?
Kiana Harris. So when all of this came about, the truth of the matter is she didn't lie on not telling me. When I found out, which was the trial date, that she had to come to court, and I found out that she was offered that deal, she honestly, and I understand that you explained it to her, but she honestly did not understand. Ashana had and still has, I don't want to completely say a learning disability, but she does have a comprehension disability on understanding certain ways. You have to break it down 50 million times, unfortunately. And that's not the court's fault. That is not her attorney's fault, nobody's fault. It just is what it is. But she has, through this entire process, at home, tried to get it together, has tried to take ownership with myself, was afraid to come in here today to face whatever it is that she was supposed to face. So she really is not that individual. She's not a bad kid.
She lied to me
I
today.
understand. And she was also, because I did chastise her in the hallway like her attorney did say. And I'm like, bite the bullet, call it a day if she asks you to speak. They just bite the bullet. She still was scared. And that's the honest truth. I have no reason to lie. I'm not under anybody's court jurisdiction. If that makes sense. I'm not in trouble.
Right.
So I'm not trying to just save her. I'm not trying to just at the last minute come to her defense. Because through this whole thing, I have been livid, completely ticked off. Because this has just been the last 4 years has just been a whirlwind for both of us. That's really all I got to say. Like this was the final toll. This has been entirely too much, just too much. She's really not a bad kid, and she really is trying. She's trying as best as she can, but she is trying. She does start a job today at 3:00. She is going to cosmetology school in November. She has been doing hair at the house, braiding and doing certain things. So she really is trying to stay out of trouble and say she has not been in trouble. This was.
I understand that this is the first offense. I get that.
Yeah.
I'm not saying it makes her a bad person. What I am saying is she came into this court. She committed a fraud on this court today in front of me. She could have just been quiet, but she stood up and legitimately tried to convince me that she wasn't there today.
You know, like they say, once you start something, you have to carry it through until you can no longer carry it through. And that is what she honestly thought she had to do. She started out on the road and she thought she had to continue with the road.
Thank you, ma'am. Ms. McDuffie, a lot of people had a lot to say since this happened. Is there anything else you would like to say at this time?
Yes, Your Honor. So with Ms. Cunningham, here's my concern. I appreciate that her mother is present. Thank you. I understand. I also appreciate her mother. It sounds like she was apparently kept in the dark along the way here, at least somewhat. Here's my concern now. Well, among all the rest of them, my issue is that my impression from Ms. Cunningham has not been at all that she didn't.
One moment. Can I have you guys switch to the other side so you can actually see the prosecutor? Okay. All right. Now, Ms. McDuffie.
Yes, Your Honor. So my issue and my concern and my observation is that Ms. Cunningham is not been a matter. I understand her mom is informing us on, obviously she knows her much better than we all do, but what I've seen is that it's not a matter of her being confused about Haida. At different points, Ms. Cunningham has just appeared to not take this seriously and behave as if it's sort of a game. And I'll explain what I mean by that. When we go throughout any case in this court, I make it a point to be very clear that this is what the offer is. I want everybody to have all discovery, know about all the defenses against them before they make a choice to go to trial. Because once you do that, and once we've talked about offers, when you reject those are off the table. A Haida offer is going to go to somebody that's relatively young by nature of what Haida is. And so that offer I explained that offer multiple times, right, to both attorneys and everything. That offer was rejected way back in May. I think we were for final settlement. We then moved to bench trial. Although the offers would normally be off the table, with the knowledge that Ms. Cunningham and Ms. Griggs were young, that they might not fully appreciate what was happening here and the impact on them that this could have, and that Haida offers you a non-public case and with it getting dismissed if you do what you need to do, I actually put that offer back on the table right before we started the trial, which I don't think I've ever done that right before a trial. So minutes before we called our first witness, we had one more opportunity to reconsider that. When I came in the building that day at a previous, I think at jury selection, I had offered Miss White, her attorney, some fruit snacks because she was hungry in my purse, and Miss Cunningham wanted some, and I gave her some. But when I came in the door the day of trial, Miss Cunningham, was beaming at me, and she said, "You got some more fruit snacks?" And I wondered why she was smiling, because we were here for her trial that can impact her future and her criminal record. And yeah, she seemed to not get it, but this was not a game at all. And that's even then, I gave her that other chance to think about this one more time. So after we had that trial, those convictions took place, and the reality of that should have been sinking in. We came here for sentencing. In September, I believe it was last month. And she had a 10-day jail recommendation then. So what gets me is that she walked into court today with 10 days already over her head. And instead of taking any accountability to try to avoid that, you informed her that that number could go up even higher. So everybody has a job that they're starting when they face some consequences. She might actually have those arrangements, but she also knew she was coming to court today facing jail time. I can't help but wonder what the coincidence might be there. But lining up other consequences for your life outside of these don't make these go away. Miss Cunningham has continued to victim blame. Even now, even through her tears, she is still saying that she is essentially the victim here. And that she has encountered all of this, what she's, describing as, I guess, harassment and abuse from the victims in this case. It's not as if she had no choice but to engage in this behavior. She had the most choice of all over her behavior today when she came into court. And mom is here today, and she knows mom is here today. I don't believe that there should be a reward for that. Now, I'm not trying to be harsh. I'm the one that wanted them to have Haida in the first place. It's the prosecutor's consent and the choice to grant Haida. And I tried to spare her from this outcome, but it's got to take, Haida's not available when you're convicted. It's got to be a plea. There's got to be some acceptance of responsibility to get that benefit. All of this could have been avoided, even from the last sentencing to today. Her co-defendant had a whole different outcome. And so it's so easy to face reality when you're sitting in that courtroom and jail is waiting on you. But to continue to aggravate that circumstance, I don't think that Ms. Cunningham didn't comprehend it. I think it just wasn't real to her. And it's really real now. She found out. So I'm asking the court, I understand the court has spoken about a range of 10 to 30, and the court may determine that 30 may or may not be necessary, but I do think there should be some, because I think that doing this at the end reinforces that it's not real and that it's something that can be gotten out of, and that she can kind of, try to find the court's favor and approval to hopefully wriggle out of that at the end. I think it needs to be up front in a wake-up call, whether it's 5, 10, whatever that number is, but there needs to be something, at least according to the people. Obviously, the court has the final call, but that's all for me.
Can I make one last statement? Just to clarify something.
Sure.
That's really, and then I promise you, I'm sure. I understand that people do come to court the day of sentencing and they all of a sudden have a job, this, that, and the third. Ashana actually lost her job the day of the trial. She was supposed to be at work that day at 5 o'clock, but since the trial extended the time, they actually terminated her employment. She's been working since she was 16. So employment has never been, I just got a job because I'm in trouble and I need to show the court something. That's not the issue. She was also diagnosed, like, I'm just trying not to just bombardly put all of her business out there like this, but when I say she had a learning disability in school, her life has been one challenge after another. So it's not a game. When she shows you, if she's just saying, hey, you got some more fruit snacks, that honestly is just her personality. It's not a game. That's just who she is. She's not taking it seriously. That's just who she is. She doesn't know how to show emotion until it's time to show emotion. She doesn't know how to all of a sudden face accountability or take accountability. It's at the last straw, and it's not just today. It has been her entire life. So I'm not making an excuse. I'm not saying she's a menace or she, needs to be made an example of, or trying to be the mother that saves their daughter. That's not what I'm saying. What I am saying is that she does understand, but it takes her a little longer than others sometimes to understand. She knew this was important. She really was, in all honesty, scared to come today. That's the honest truth. Almost didn't come because she was scared of the consequences. It's not a game to her. She's never been in trouble to this severity before. And I was in trial from the date of the trial. I had no idea that the Haida was put back on the table that day, because she would have took it that day had she told me or had I been made aware of this then. And that's the honest truth. I did not know at all. It was, we're here at trial, we're going to wait for the judge to call us, and that's what we did. Sat in the hallway and waited for you to call us.
Thank you.
Ms. White? You ready?
What's that?
We ready? You ready? All right, please stand, ma'am. All right, it is the sentence of this court that you serve 365 days in the Washington County Jail. Credit for no days. You are going to serve 1 day immediately. The balance of 364 are suspended. If you come into court and lie to me again, then I'm going to be giving you 30 days of jail. You understand that? I don't know if they'll take, will they take the one? I mean, I think the minimum I can do is 5. I'm gonna see if they'll take the 1 day. Because I think the minimum that they tell us they'll take right now is 1, but I need to make some phone calls to see if they'll take her for the 1 day. You're on probation for 12 months. Fines and court costs in this particular case for a total of, what did I do in the other one, 525? They're the same. I think it was 525. $400 in restitution for the damaged window. That's joint and several between the two of you, you and your co-defendant. I'm gonna do a review in 45 days. I believe I put that on December 7th at 10 a.m. Ma'am, go with the officer.
Your Honor, I just want to clarify, if the jail does determine that it cannot be 1, does that convert to a sentence of 1 to 5 days, or does it just convert to no for jail at all?
I'm deciding on that.
Okay.